Deliverymen and drivers for online platforms could be designated as a new worker category. Now, this would help them better understand their legal protection and eligible support schemes. The Manpower Ministry is considering this as it seeks to table a new law on mandatory insurance and CPF contributions for platform workers. But first, MOM is getting public opinion on how to define platform workers and operators and their duties in ensuring safety and health. For instance, operators need to have risk control measures like setting reasonable time expectations for job fulfillment so that workers won't need to rush, or having mechanisms for the public to report unsafe driving or riding behaviours. As for platform operators, the proposal is to define them according to three prongs. First, that the business model collects data to match customers to workers. Second, that platforms receive any form of payment, including commissions for the service done by the workers. And third, that an operator can control how the service is performed, such as by limiting work hours or fees. The public can share their views from now until September the 4th.
To understand the legal issues concerning platform workers, we speak next to Jonathan Yuan. He's Head of Employment at Raja and Tan Singapore. Mr. Yuan, my colleague Jill was just outlining, I suppose you could call them the legal entitlements if you fall within a distinct legal class of platform workers. That's why it matters so much whether or not we want to come up with that distinct category. Is that why it matters?
That's right, it absolutely matters. That's because currently now the Employment Act looks after workers only that are classified specifically as employees. So we need to understand employees as in contradistinction to independent contractors. Employees have the protection of key employment terms set up by the MOM. For example, you have your entitlement to leave, maternity leave, protection, on overtime pay and things like that. But independent contractors don't have that. Now, we have to understand that all these acts were passed a long time ago. The Industrial Relations Act, which talks about employees, was passed in 1960. 10 years ago, we didn't, it wasn't a habit for us to pick up the phone and call a delivery for someone to deliver pizza on a public holiday. Now it's part and parcel of our lives. So the law has to catch up onto that. And what the Singapore government has been doing is to engage with the industry through the Tripartite Advisory Committee to kind of create additional protections for these platform and what we call gig workers.
So obviously you've come to the conclusion that a category is needed. And you're still soliciting feedback from the public, I bet. But surely there must be some sort of precedent or some sort of model that's been enforced successfully in other countries that you're also looking at.
Absolutely. And other countries are struggling with this issue as well. And I think that looking from how, for example, the Americans are doing it in California, they've had significant litigation over Proposition 22. It was first declared unconstitutional that these workers are independent contractors, and then recently the California Appeals Court reversed it and said that it was constitutional, and I suppose with all things American litigation will go on for a significant time yet. Yeah. The British, on the other hand, have classified a hybrid and in-between classification of these workers as essentially workers. So they're kind of a halfway house between an independent contractor and a full-on employee. So the employer will have to give them certain basic benefits like mandatory health insurance, minimum wage. I mean, it's not entirely apples to apples in Singapore because we don't have that. But it also gives them the flexibility to choose the type of work that they have. So we don't have that yet, but I think what the MOM is doing is moving incrementally as well by adopting all the recommendations made by the Advisory Committee on Platform Workers.
Right. Correct me if I'm wrong, because I would not understand the minutiae of employment. So, for example, you're talking about pizza delivery workers before. The fact is they often wear uniform, and I don't know, a pizza delivery worker or a Burger King delivery worker, presumably different companies, they might actually be employed by them. So it would not be the same as a completely independent platform worker. How would you create a hybrid class that would cover all these semi-involved with their company type workers?
Yeah, so you're very correct to point out this competing tension. On the one hand, you have the commercial freedom for someone that wants to work for company A and then do some work for company B and company C in the evening. and to pick and choose at what point in time he or she wants to make such deliveries or do such trips. On the other hand, how do you protect these people when they're out, when all the various platform companies that deal with them say, well, you're on your own time now, and perhaps if you fall down, then too bad. You weren't doing my work at that point in time. So I think the very practical approach the Singapore government has done is to basically say, well, we won't legally change the fact that you are not an employee, i.e. we won't make you an employee, but we'll give you the type of protection that the Workplace Injury Compensation Act will give you, WICA will give you, if, for example, you hurt yourself during a delivery.
Right. Okay, so I'm just wondering how robust that is, what you've just told me is, okay? Because, the framework needs to be in place to ensure that nobody falls through the cracks. Right, these workers don't fall through the cracks and run foul or run, or at the mercy of perhaps operators that are trying to sort of legally outmaneuver them.
Well, I think that as a starting point, I think most large operators in Singapore are responsible companies, and they try to do their best. I mean, there'll always be the rotten egg, but we can't plan an entire policy based on outliers. But by and large, I think that this incremental approach will be a data-driven approach. These are just very early days. I think the most important thing are that injuries are now covered, CPF is now covered, and the workers also have representation. The latest recommendations that came out in early July have also been accepted by the government, all 8 of them. So I think we'll work a little bit by bit, and the MOM has already said that they look forward to coming up with legislation in about 2024.
All right, the new measures expected to kick in second half 2024.
That is correct.
2021, they were identified specifically as a vulnerable group, 88,000 platform workers.
That's right.
Hard to push you on a date here.
Yes.
But when do you expect any kind of firm legal agreement, and what do you foresee it might be?
Well, that's a tough one because I'm not the MOM or I'm not the government. But I think industry watchers are expecting that the consultations with industry groups like lawyers like ourselves and platform companies will continue throughout 2023. And I think first drafts will start coming out by early 2024 or so.
Okay, and you didn't answer the question.
Right.
You wouldn't know what to. Thanks so much indeed.
That was a tough one indeed.
Jonathan Yuan, Head of Employment at Raja
Thank
in
you.
Town, Singapore.